Welcome to the Massachusetts School of Law's Educational Forum. This program is produced by the Massachusetts School of Law and is shown nationwide. For close to 30 years, it has been illegal for the government to use sophisticated electronic devices to spy on Americans, at least if it's done without a court's approval in advance. Congress attempted to guarantee that privacy for U.S. citizens when it passed the Foreign Intelligence Surveillance Act in 1978. That law created a special secret court, one that meets behind closed doors at the Justice Department, to review the government's requests to engage in gathering foreign intelligence that may directly affect Americans. We now know, however, that since soon after the terrorist attacks of September 2001, the Bush administration has been electronically scanning calls and emails involving what government officials thought might be home front terrorists. This super secret program was revealed late last year by the New York Times. It turns out that the administration did not have the special Foreign Intelligence Surveillance Court's permission to do this kind of eavesdropping. In fact, the government did not even seek court approval, believing it was unnecessary. One or more internal Justice Department memos that have never been released or acknowledged to even exist have apparently argued that the government could legally go ahead without a court-approved warrant. Since the disclosure of the program, President Bush, Vice President Cheney, the Attorney General, and other top officials have mounted a fervent public defense of the program and of its legality. All that America knows about the program is what those officials have been willing to discuss. They have said little about its details, but they have said much about what they believe to be its legal justification. There is much argument on the other side too, and today we will be discussing how this all came about, the reaction to it, and what may happen next. With me for this discussion is Kate Martin, who is the director of the Center for National Security Studies, a human rights and civil liberties group based in Washington. Kate is an expert on domestic intelligence, has taught courses, tried cases, and testified before Congress on such issues. Also with us is Lyle Denniston, a veteran Supreme Court correspondent who appears regularly on these programs, and I am Constance Rudnick, a professor at the Massachusetts School of Law. Welcome, guests. Thank you. Why don't we start out with a basic question, and that is, one of you explain what FISA, the FISA court is, and what it does. Kate, you want to start?
Sure. The FISA court was set up in 1978 by the Congress to stop what had been the practice of secret, warrantless eavesdropping on Americans. And it provides a procedure where the Attorney General can go and make a showing to the court, get a warrant based on probable cause, and conduct a wiretap of an American. And the difference between this kind of FISA surveillance and usual surveillance is that the person who's wiretapped is never told that the government listened to their conversations. And that's the key civil liberties privacy problem in the whole system. And so the counterpart to that is to make sure that there's a warrant and judicial oversight at the beginning of the process, because the person who's heard and whose conversations and emails are listened to or read is never told about it.
Okay. Do these apply, does this statute apply to the same kinds of criminal investigations that our local police force might get a warrant to intercept communications involving sort of garden variety crimes?
No, and there's a separate statute called Title III that provides for criminal wiretaps, and including of telephone conversations or emails. And the main difference is that there has to be probable cause of a crime. The court has to issue a warrant, but that when the wiretap is finished, the person who was heard is notified. And that's a basic check on government abuse that's missing on the national security side.
Okay. Are the crimes for which these intercepts are obtained the same, the FISA versus a sort of garden variety intercept?
Well, remember, Connie, we are not, in using this kind of surveillance, we're not looking for crimes as such. We're looking for foreign intelligence.
Okay.
And that may mean that some American laws have been violated, but it may not mean that at all. It may mean that the government is simply looking for intelligence data, that is the activities of a foreign power. And remember, this is the targets for this kind of surveillance are U.S. citizens or associations, but they have to be suspected of being agents of a foreign power. And as Kate pointed out, when you go to this special court for an order allowing you to carry on this kind of surveillance, the only showing you have to make is that you have reason to believe that an agent of a foreign power is undertaking communications that might constitute foreign intelligence. You do not have to make any showing that any crime has been, is being, or may in the future be committed. So that it's really a very low threshold that the government has to meet in the first instance to get this kind of approval.
Okay, so even under the statute, it's possible to intercept an American citizen having conversations with a foreign government that do not constitute any criminal activity either against the United States or anywhere else. Is that fair to say, or is that an overstatement?
Oh, that was the purpose of the statute, was to allow those kinds of conversations to be intercepted, but in accordance with some kind of process.
Okay.
Well, one material difference, though, is that between the procedure under FISA as it was set up in 1978 and what the government has been doing for the last 4 years, is the government is not targeting an individual the way it does when it has a FISA warrant. It is data mining. It is making a sweep of telephone calls, emails, using technology that can retrieve data of all kinds of communication that existed between the U.S. telephone, any telephone, and another country. It can suck all of this in less than 1 minute for one country, and you get all of the conversations that have occurred in that time. So you're not targeting anybody, you are targeting a connection with a foreign telephone or a foreign communication source. You're not looking for a specific individual, you're just essentially fishing.
Okay.
And that's what's going on.
I want to get in a minute to how the government is determining where to put down its bait and its hook in this fishing expedition. But before, I think we need to get into a little more of the secrecy. Kate mentioned that one of the problems is that there is no notification to the victims or the subjects of the wiretapping. What else is there that makes this the super secret court, as we talked about in the introduction?
Well, the other part is what Lyle mentioned, which is that the probable cause requirement is much lower than it is in the usual criminal wiretapping instance. When Congress passed this law in 1978, what they were trying to do was to balance the government's national security need to gather foreign intelligence, as Lyle said, against the Fourth Amendment warrant protections for individual privacy. And so they set up these procedures that are somewhat detailed, but are carefully meant to balance. And they then went a step further and said to the government, these are the only procedures under which you can wiretap Americans for national security purposes. And the statute made it both exclusive, those procedures, and made it a crime for government officials to wiretap Americans without going and getting a FISA court warrant. Mm-hmm. And it did that to stop the abuses that had happened.
That had predated the 1978.
Exactly.
But there are other aspects of it that contribute to this super secret character and the impression that it is something that most Americans don't know about and are not ever going to learn about. This is a court that meets only at the Justice Department, in the special courtroom down there. Only one side appears before the court when the government's seeking the authority to wiretap. That's the government of the United States. If there is an appeal, and there's only been one in that court's entire history since 1978, only the government can appeal if it's been disappointed before that court. If it goes to the Supreme Court, it can be taken there only by the government of the United States. And this court does not have any public accounting, excuse me, of its conduct, of its activities. Once a year, they report to Congress a total number of warrants that they have authorized, and that's all. That's all.
And not the circumstances under which the warrants are. Now, how do those members of the court get to be on the FISA court?
Well, I believe they're placed there by the Chief Justice of the United States, who usually makes temporary appointments to lower courts. There are 11 judges now on that court, and most of them, of course, were appointed by late Chief Justice Rehnquist. I believe Chief Justice Roberts has now appointed one new member of that court.
And do they rotate? These are
Yes.
for terms of years?
Yes.
They do.
Okay, all right. Now, assuming that George Bush has in fact expanded the scope of what might be covered by FISA, is he the only president who's ever done that, or has there been have there been other presidents who have made efforts to expand the reach of FISA or to gain foreign intelligence without complying with the requirements?
No president, since the passage of FISA, which said, if you want to conduct secret national security wiretaps, here's the way you have to do it. No president since then has said, I'm going outside the procedures that are required by the law. Now, the Bush administration has put out these misleading statements about past practices by presidents, which we could talk about, but no president has said, well, despite the fact that FISA says this is the only way to do it, I'm going to do it differently and do it without getting a FISA warrant. Bush is the first president to do that.
What is it, the legal justification that the Bush administration is claiming? It sounds like they don't have any. I mean, they must be claiming something.
They have a fully developed argument which they have really very widely publicized since the Times disclosure of this program. They start with the Constitution and their argument that the president's power, particularly his power during wartime, which they consider the current situation to be, the president has the inherent power, that is, power given to him solely because he is president, to wage war as he sees fit. So that's their starting point. They say the president ultimately has this authority on his own without a statute, without any by your leave from the courts. And once they've gone through that argument, then they have a fallback argument. And it's the fallback argument that attempts to answer the criticism that this is the exclusive procedure. They say, oh no, the statute says that except authorized by law. So they say this program is authorized by law. And you say, what law? They say, well, the 9/11 resolution, that authorization to use military force that Congress passed overwhelmingly in the wake of the 9/11 attacks. That's their second fallback position.
And their position would be that peaceful interception, secret interception is force? The use of force?
No, they're claiming that the resolution is open-ended. They're saying that the president can do anything he needs to do to find, locate, pursue, prosecute, kill anybody who is involved with Al-Qaeda. They're reading the resolution as expansively as it can be read. And under that authorization, they believe the president can do it if he can't do it on his own inherent power. They have two other arguments, none of which is particularly persuasive, nor do they rely very heavily on them. One is that they think the Supreme Court has already impliedly authorized this by its decisions in 2004, ruling that the 9/11 resolutions allow the president to detain foreign nationals and American citizens. They said, well, the Supreme Court read into the 9/11 resolution something that wasn't there in terms, in words, that is detention power. So by implication, the 9/11 resolution also authorized the president. The other thing they argue is that there are past court precedents that sustain this. The problem is that all of the precedents upon which they rely predate the passage of the FISA Act.
Is there anything in the Act itself that would authorize this? Is there an exception, any language in the Act itself?
No, but what the Act does is it anticipated this kind of situation because it has two exceptions to it. One is that they can wiretap for 72 hours without getting a warrant in an emergency situation.
72 hours are up, I think.
Yes.
Okay.
Yes.
They haven't invoked that. And the other provision of the law says that after a declaration of war, the president can wiretap for 15 days without getting a warrant. And then presumably, if he needs additional authority, he's supposed to go back to Congress to get it. What this president did is during those 15 days, he went to the Congress and presented the Patriot Act, which included amendments to the Foreign Intelligence Surveillance Act, but no amendments that would authorize this warrantless program. And he failed to disclose to the Congress that while he wanted the Foreign Intelligence Surveillance Act amended in certain respects in the Patriot Act, that in fact he intended to ignore it altogether and wiretap without a warrant. So.
Okay. Why didn't the government ask for a warrant? I mean, is it just brazen disregard, an attempt to test the limits of presidential power? I mean, what
taking them
is
at their word, Connie, the government says that we did not ask for a warrant because we didn't believe we needed one. We operated on the basis of this, we believe the authority. They don't acknowledge that there is a memo, but John Yoo has said that somebody wrote a memo. He doesn't acknowledge that he was the author. He's a former Justice Department official who gave them a constitutional foundation for the argument. So that the government basically claims we just didn't need a warrant. Now, there also is a strong suspicion, we don't have any objective evidence to support it, that the administration thought that if they asked for it, they wouldn't be able to get a warrant because it is not a targeted program. It's not a program that singles out an individual to monitor that person's calls or emails or other communications. It's a program designed to sweep, to find people to monitor. And so I think they thought they couldn't get a warrant. You know, that court has been very compliant a lot of the time, but in the early years of the Bush administrations, they did put up a little resistance, and the administration got very uncomfortable with that kind of resistance because the court had never done it before. And moreover, it now turns out they thought that court didn't have the authority to reach beyond what it had always done, which was essentially to rubber stamp what the government wanted.
Okay. Let's talk for a minute, the best we can, based on whatever little information that we have. Who's being targeted, and how are they, and how is this targeting going on? You mentioned phishing, minesweeping, all that kind of stuff. What's the government doing as best we know?
Well, if you start with what the President and the Attorney General have said, what they've said is we're only, no, they didn't say only. They said we are monitoring conversations between someone in the United States and someone overseas when one of the parties to the conversation is either connected to Al-Qaeda or has some link with Al-Qaeda. But then they have a second part of their statement, which is, but there might be more. And over again, while the President claims the only thing we're doing is listening to Al-Qaeda, when the Attorney General is pressed before the Congress, he's very careful to say, well, we're doing this, but we could well be doing more, but I refuse to tell you whether or not we're doing anything more. So that's where we start from.
Okay, my first question is there like a roster of Al-Qaeda people somewhere that they look up and then they go, plug in their phone numbers, and how do they know if somebody is a member of Al-Qaeda?
Well, they have a lot of intelligence about Al-Qaeda. They do have lists. I mean, they make up lists for various surveillance purposes, and they have a watch list on who can enter the country, and they have a watch list on who can fly on airplanes and that sort of thing. So they do know the identities of individuals. They've gotten a lot of this from people whom they've captured overseas, like Khalid Mohammed, others, the top leaders of Al-Qaeda that they have taken captive and still hold overseas, and have probably been able to torture to get additional information out of them. So they have a lot of information. So they know what they're looking for when the data sweep starts. They know what kind of numbers they're after in what kind of countries.
Okay, we need to take a break, but we're going to pick up on this question if you just hold that thought, and we'll be back very shortly, and when we are, we hope you will be too. Welcome back to Massachusetts School of Law's Educational Forum. We're here with our guest today talking about the administration's warrantless eavesdropping program. When we left, Lyle, you had just finished talking telling us that in fact they have identified individuals who they believe to be associated with Al-Qaeda, and those are the persons who are at least on one side of the conversation.
That's what we believe,
okay.
In part.
All right. Now, so I guess my next question is, well, if they know these individuals, and they know or have reason to believe that they're part of Al-Qaeda, wouldn't they have been able to get a warrant to intercept any conversations that those persons had with American citizens or those lawfully in America, or if they're actually the Al-Qaeda persons, to intercept whatever it is that they're saying with anybody?
Yes, there's no question that if you're talking to Al-Qaeda, they can listen to you. Either they get a warrant, or, and the administration has been totally misleading about this, if they're targeting Al-Qaeda operatives overseas, they don't need a warrant, and they can listen to anybody who calls them up.
That would be that would be two people overseas
who are Al-Qaeda. Okay. And so while the president's been very aggressive about we're only listening to people talking to Al-Qaeda, what the administration has failed to explain is, if that's the case, why didn't you get a warrant when you need a warrant in the United States? Or if you're doing it overseas, you don't need a warrant. So it leaves a lot of suspicion that what's been reported in the paper is in fact true, which is that the program's much wider than that.
So it's not just, at least the criticism from the civil liberties standpoint, for one, is that apparently what the government has acknowledged is happening is not the only thing that's happening, because if that were it would be very simple for them to have complied with FISA.
We keep hearing these kind of code phrases, from the Attorney General and the other apologists for this program, which suggests that in fact all they want you to think they're doing is going after Al-Qaeda, but the reality is they also are saying that we may be doing more, but we can't acknowledge that because it's highly classified. We don't admit that we're doing more, but we don't rule it out. In fact, I think the Attorney General said recently, we're not going to rule out the idea that we're doing surveillance entirely within the United States, without a connection overseas. So what's visible now, or what we believe is visible now, is maybe only the smallest part of a very large program.
And it's a political game, I think, because everyone of course, supports the idea and the legality of wiretapping conversations with Al-Qaeda. And the question is, are they wiretapping other kinds of conversations? And they refuse to answer that question when there's a lot of evidence that apparently they are.
Well, certainly they're able to ride the terrorist horse pretty far, because no matter what polls one looks at, the overwhelming majority of Americans believe that intercepting communications which will lead to the discovery of terrorists and terrorism is a perfectly legitimate and laudable effort on the part of the government.
Indeed.
So, most Americans are going to say, well, who really cares how they're doing it, as long as the end is they're finding people so we don't have another 9/11. So,
but there's already some evidence, and this comes from people, who've been known to be surveilled by other means, that peace groups or peace activists or church groups have a strong suspicion that they have been targeted by this, and that the administration may in fact be using this program. We don't know this for sure, but may in fact be using this program to monitor people who are opposed to the war in Iraq, or other groups that are engaging in peaceful activities. So we remember this program, the FISA program, was a reaction to Richard Nixon's administration's use of secret wiretap overhearing of people who were, quote, enemies, unquote, of the Republican administration at that time. So the suspicion is very strong now that at least in some dimension, some part of this program is being used to monitor dissent in this country.
Because remember, the warrant requirement functions for to protect national security interests as well as privacy interests. I mean, in the first instance, it helps to ensure that the government focuses its resources on people when there's some actual basis to suspect that they're bad guys, or in this case, involved in terrorism. And there's some judge looking at it and saying, yes, you know, it makes sense to spend hundreds of person hours and thousands of dollars to target this person because you have some information that they're involved in terrorism. And the other thing the warrant requirement does is it ensures that if they do get incriminating information from these wiretaps, that they can use them to prosecute the terrorists. And both of those national security objectives are jeopardized by a program of secret warrantless surveillance outside of the law. And there's been no explanation about why they wouldn't want to get a warrant.
So the Bush administration is really taking a chance here, because if in fact it turns out that they're not correct in their appraisal that this is perfectly legitimate, and some court decides that, they could throw all this information out, and in fact it would hurt a prosecution as opposed to going through the safer route, which would have been to create a safe harbor by going to the court and getting a warrant, which is almost never subject to attack.
Exactly. Well, and already, you know, there are intimations, at least in some of the pending court cases, that people who have been prosecuted for quote terrorism unquote crimes or acts of material support of terrorism have been the targets for this very kind of surveillance. And there are now at least 5 cases that I'm aware of in this country where people who have been convicted or have been charged with terrorist crimes are seeking to at least have an inquiry into whether or not they were targeted. And if it turns out that they were targeted, and it also turns out that the program is
law enforcement officials who are sitting somewhere with earphones on, listening to the content of conversations. Mm-hmm. Is that happening? Do we know? Is there somebody who's physically listening, or are they just going through and, you know, pulling out snippets or full conversations, recording them, sticking them someplace? Do we know whether there's somebody actually looking at them, or are they just saving these for a rainy day?
Well, the press reports that it's the National Security Agency rather than the FBI that's doing this surveillance. And the National Security Agency is set up to do incredibly large volumes of surveillance. It's always had the capability to, as Lal says, vacuum up millions of conversations and emails, you know, every minute. It also has the capability to sort those communications with computer, and then to analyze them, to listen to them in a sense by the computer, and then to store them. And in fact, some of the administration's apologists have argued that if the computer has your conversation, no harm, no foul. Somehow that's not the government seizing. But I find that argument to be, you know, in fact, when you say that law enforcement people sit there with their tape recorders on, I'm not sure that it actually happens these days. I think it's just as likely that the FBI turns on a tape recorder. The tape recorder runs 24 hours a day, and then later they listen to the tape recording. And what we have here is the NSA turning on 50 million tape recorders simultaneously and storing them in their databases for whatever use and whatever analysis the NSA or the White House decides they want to make of them.
Okay. I remember reading that in 2002, I think it was, the Justice Department was asked specifically by Congress whether or not they needed an extension or an expansion of FISA in order to accomplish their goals. And they said, no, we don't. So if they believe that there is some urgency out there which would necessitate their proceeding without a warrant under certain circumstances, why didn't they just go to Congress and say, yes, you know, we really do need something because we don't think that this FISA, the existing FISA procedure is going to give us the tools necessary to fight the kind of terrorism, that's international terrorism, that's going on right now.
I think they have 2 arguments as to why they didn't go. One is the one that they don't push very strongly because it sounds disrespectful of Congress. They didn't really think Congress could appreciate the need for it, and that Congress probably wouldn't have given them the permission. The second thing that they say, and they probably believe this one more than the first, is that they feared that this would lead to a disclosure of the program, because when you ask for legislation, you're inviting a potential leak and a public disclosure of the kind of thing. So they say we didn't want to take the risk of doing it, partly because we don't think we would have gotten the permission to do it, but even if we did ask for it, there's a risk of disclosure. And then, of course, they add once more their major argument, which is we didn't need it. We didn't ask for it because we didn't need the authority of Congress to do it, because the president can do it on his own.
Was this was the warrantless intercept program something that was a unanimous agreement among all the administration individuals, or was there some dissent in within the administration that might give us a clue as to whether they had second thoughts about the legality?
We don't know.
Okay.
There's
rumors only.
There's been press reports that there was dissent. We do know that they didn't tell many officials, and in fact, some senior level Justice Department officials went to testify before the Congress about FISA and the Patriot Act and electronic surveillance of Americans. And when you read their testimony now, it's completely misleading, because it clearly implies that all surveillance that's being done of Americans is being done under the Foreign Intelligence Surveillance Act. And it turns out that that official at the Justice Department, who's a high-level official, had not been told about the program. And
so he, as far as he knew, he was telling the truth.
That's right. And I think the mere fact that they held it so closely indicates that they understood that it ran counter to, what people have been taught who worked at the NSA and the Justice Department forever, which was we only wiretap Americans with a warrant. And that's why the program leaked, is because you can see that people who worked inside, not in the Congress, this did not leak from the Congress, it leaked from the executive branch, because people who knew about the program felt more and more uncomfortable about its legality and its constitutionality. And I think one of the serious constitutional questions here is the president's deliberate deception of the Congress, as well as of the American people, in not simply keeping secret the classified details of the program, but in misleading everyone on his view of the law, in which there's no excuse to keep that. He never told the Congress, he didn't even go this, never mind telling the Congress, here's the program that's going on. He never said to the Congress, by the way, when you amend the Patriot Act, I just want you to know that I don't consider the Patriot Act to be a limitation on my authority. And I don't consider the Foreign Intelligence Surveillance Act to be a limitation on my authority. I consider that when I deem it necessary, I can act outside the restrictions and the limits of the Foreign Intelligence Surveillance Act. There's no excuse, and I don't know of any precedent for a president deliberately withholding that from the Congress.
So why, if that, is it true that nobody in Congress had any information about the secret wiretap program prior to its surreptitious release by the New York Times? I thought that there were some.
Well, I think it's pretty clear that some members of Congress had an intimation, if not explicit information, though it isn't the kind of information, if they did possess it, it isn't the kind of information that would have given them even the closest clue to the dimensions of the program and the dimensions of the president's mistreatment of his relationship with Congress.
So if I were sitting in Congress, I would be not a particularly happy person no matter which side of the aisle I was on, because this administration appears to believe that its power is highest when it acts by itself pursuant to what it perceives is some reservoir of foreign relations.
Well, Connie, there started out when the program was first revealed, there was a fairly heavy flow of skepticism out of Congress, including from some Republican members, particularly in the Senate. You know, we have serious problems about this, and I think Senator Specter, the chairman of the Judiciary Committee from Pennsylvania, said he thought that the program was probably unlawful. The other senators have raised questions about it, but that kind of skepticism that originally arose seems to be ebbing now, and what they're looking for is, Republicans are looking for a way to protect the administration in some dimension, if not authorizing the program as such, but finding some alternative way to protect the administration from an ultimate confrontation over the illegality of the program.
So Congress is not concerned that the president appears to be acting unilaterally? I mean, we have a government of checks and balances. Congress is supposed to have a role in creating the law. The president is truly supposed to only effectuate or carry out the law that is, in most instances, made by Congress. So Congress now is not concerned that the president has acted unilaterally without.
Well, Congress is divided. You know, many Democratic members, including some conservative Democrats like Senator Feinstein from California, expressed great outrage about it. And even Representative Sensenbrenner, Republican from Wisconsin, recently complained about the Justice Department's withholding information about the program from his committee. But at the same time, and of course we have Senator Feingold's censure resolution, and that's about the fact, not about whether or not the wiretapping should happen or not, but about presidential lawbreaking and the president deceiving the Congress. That's the basis for that censure resolution. But at the same time, it's clear that Vice President Cheney went to talk to the Republican senators, and after he did that, the Republican senators have mostly lined up to say, we'll fix this.
Okay. We need to take another break. We will be back, and we hope you'll join us then. Welcome back to Massachusetts School of Law's Educational Forum. Do we have any idea how successful or effective this program has been? Do we know whether or not the administration has actually uncovered information or individuals who might actually be a threat or provide information for the United States?
You know, that's one of the questions that the administration has refused to answer to the Congress. And it's an outrage that they've refused to answer the Congress. The president or the attorney general, I forget, made some reference in a speech about a couple of terrorism cases that had benefited from this program. But then there was some follow-up reporting saying it didn't look like that was the case. And one of the questions you have to ask is, well, if the wiretapping really found terrorists, then you'd think they would go get a FISA warrant and end up either arresting the terrorist or deporting the person or something. And that doesn't appear to have happened because, I mean, we don't know, but there's no evidence about that one way or the other. And you know, the question of effectiveness, of course, the real question is not, has this program found any terrorists or helpful information, but was it necessary, even if it did, was it necessary to conduct the program in this way? Would getting a warrant have meant that you didn't find that information? And that's the question that needs to be answered. And it's very hard to imagine how getting a warrant would have made it more difficult to get any useful information.
But it would seem to me that the bottom line here is I clearly can understand where you and the position of your organization is, but you've really got an uphill battle because we've got hundreds of millions of people in the audience. Well, maybe they're not all watching, but hopefully they are. And what they're saying is, you know what? I don't want another 9/11. I don't want another terrorist taking out one more person in the United States. And if this is what the president has to do in order to make sure that I'm safe, then he should go right ahead. So, and I think this is maybe why, Lyle has indicated, why there's been a collapse of the Republican opposition, and now they're lockstep behind the president, because it's not in their political best interest to do anything that somebody could point to and say, you're soft on terrorism. So, you know, why not? Well, if I were the administration, I'd say, hey, you know, even if it turns out to be, even if it's possibly illegal, nobody's going to challenge us, because anybody who politically who challenges us is going to be perceived as being somebody who's soft on terrorism, because people are willing to give up civil liberties if it means stopping Al-Qaeda from blowing up one more building or taking out one more group of innocent bystanders.
Well, but you have to look at this in a couple of different ways, Connie. One is, if you want to be idealistic about it, we have a system, and it was created in 1978, and it's a system that worked, and worked very well for a long period of time, to enable the government to gather the kind of foreign intelligence it needs to protect against another 9/11. That system, no one has yet shown at all that that system did not work. So the question is it right? Maybe the vast majority of the American people have not yet engaged the question of whether it is right to do so. But ultimately, perhaps with public education of some kind, you can begin to make the point that a lawless pursuit of terrorism is not the way that America does things. Now, that's on the idealistic level. On a very, very pragmatic political level, the question is, this is a program which ultimately may well be found to be unconstitutional, and then what are we going to do about it at that point? The administration is going to stop the program? Is it then going to be chargeable with the argument that you, in fact, failed at an activity that could have worked if you'd done it the right way? And no one is to say that if this program continues as it is, that American people will be one iota safer than they are now. The reality is, as Kate pointed out earlier, the reality is that America probably would have been safer if they'd done it the right way.
And I think that that's the question, is that there's no necessary connection between violating the law and the program and being any safer. And in fact, if you look at the history of intelligence failures leading up to 9/11, then you look at the history of major intelligence failures leading, as even the president now acknowledges, to the war in Iraq. To say that, well, we should just turn it over to the secret National Security Agency as to how best to conduct surveillance of Americans to find the next terrorist makes no sense at all. The point of judicial oversight, the point of congressional oversight, and then the point even of public debate is to ensure that we have the most effective means possible. There is this perennial implication and assumption by this administration that somehow by violating the Fourth Amendment we'll automatically be safer, when the two things aren't necessarily connected at all.
You mentioned before that there are some lawsuits pending, Lyle. Now, who brought these lawsuits? Are these subjects or victims of this warrantless intercept, or what? And what's going to happen? Is there really going to be a resolution in the courts of whether or not the program is
There are really three different kinds of litigation, actually four, because Kate's organization has filed a paper with the FISA court to try to bring up the other side of the argument. Now, whether or not the FISA court will pay any attention to that, we don't know, because its processes are secret. But there are three other kinds of activities. One is an interesting lawsuit against AT&T by people who use AT&T's long-distance service and its internet service. And they are claiming that their rights were violated by this program because AT&T turned over its data search capability to the NSA in order to monitor these people. Their rights, not only their rights of constitutional law, but their rights under the communication privacy laws of this country were violated. There are then those cases by people who believe they were targeted by the NSA program and were later prosecuted for terrorism or terrorism-related crimes. Then the fourth group are two lawsuits by the the ACLU, and the electronic
Center for Constitutional Rights.
Center for Constitutional Rights, undertaking to on behalf of people who use international communications to demonstrate, get the courts to hold that their rights were in fact violated by this program. So there is at least a possibility, I think it's not a remote possibility, that out of one of these forums we will get a declaration that, as to whether or not this program is in fact a violation of the Constitution or of FISA itself.
Unless the plaintiffs can prove, or a plaintiff can prove it represents an individual who has actually been harmed by this program, and we don't know who that is, then how do any of these individuals have the right to bring a lawsuit challenging the constitutionality?
You don't have to prove that you were a target. You have to prove that you have suffered an injury. And in these lawsuits by the people who are not prosecuted for crimes, they obviously have suffered an injury if the program was illegal. But for the people who are just peaceful citizens who are communicating with friends and contacts and overseas, all they have to prove is that their use of international communications facilities has been curtailed because of this program.
So they say, I'm not talking anymore? I'm not talking overseas anymore?
No, indeed. I mean, their argument is that we are regular, for example, lawyers at the Center for Constitutional Rights, they're involved in a lot of ongoing conversations with people in countries that are suspected of being places that harbor criminals and terrorists. And they are saying, we cannot communicate with these. We cannot carry on our law practice. And so that is at least an arguable injury without having to prove that they explicitly were targeted. So,
although I do think there's some bad law on the other side, where if you don't have admission from the government that you were eavesdropped on, you may have a hard time actually. And that is the issue that's right now before the courts, whether or not they can go forward. So the other possibility that we shouldn't forget is there are two bills at the moment introduced by Republican senators in the Congress which attempt to short-circuit this and basically to retroactively authorize the program. And although one of the bills is described as seeking a judicial determination of its legality, in fact, both of the bills would, in essence, amend the law and authorize the program. And the problem with that approach is that Congress is legislating in the dark. They would do that without knowing anything about what the program's really about. And it's an incredible...
Well, they clearly believe that we believe the president. When the president says, and this has been his response. His response is, I would never do anything to jeopardize the civil rights and civil liberties of Americans, and I am doing this to protect you. That's the buzzword.
But
they believe him.
No, but it's incredible because the program, the proposed bills do not authorize the surveillance that the president has admitted to. The proposed bills by both Senator Specter and Senators DeWine, Hagel, Snow, and Lindsey Graham would authorize a much broader, non-targeted surveillance program of the kind that Lyle described, when the president hasn't admitted that they're conducting that kind of program. And so you have to ask...
Maybe not admitted to the public. Maybe they know something that
we
don't know.
And you have to ask what their responsibility is as legislators, as the third branch of government or the second branch of government, to write a blank check to the president without knowing anything. Where is their responsibility to us?
Well, if the us is the American people, I can hear lots of people in the audience this minute saying, well, you know, if all I'm doing is having a conversation with my cousin who happens to live in Iran, and we're not talking about anything bad, then they can intercept us until the cows come home, because I've got nothing to hide, which is the reaction of many Americans, and that is, if I've got nothing to hide and I'm not doing anything illegal, then what's the harm? So we're protecting the civil rights of people who are involved in insurrections or attempting to overthrow the United States or engage in conduct that might be detrimental. I don't care if we're trampling on those people's rights.
You know, that is the political judgment that people are probably going to be making regularly along here. But we were hearing that same kind of argument that people didn't care at all about capturing foreign nationals and detaining them forever without any legal rights at all. The people didn't care about that because these were bad people who had been doing bad things. But ultimately, the Supreme Court of the United States, that a state of war is not a blank check for the presidency. Right. So you see, whether or not the public is agitated about this, whether or not it approves of this, whether or not it's disinterested in this, ultimately may not make the difference if, in fact, the courts are still open, still sitting, and sitting there with the responsibility and the opportunity to make a constitutional judgment. And that's the kind of constitutional judgment that will get made at that time, not on the basis of what's popular about this program, what's popular about fighting the war on terrorism, but about whether or not the President of the United States has actively and intentionally subverted our constitutional order. That's where the ultimate reckoning could come. Whether it will or not may depend on the kinds of appointees that get made to the federal bench around the country and the Supreme Court.
Although I'm actually optimistic that if the issue got to the Supreme Court, that the Supreme Court would disallow it. And I think the reason is because if you're a strict constructionist on the Constitution and you read the Constitution to mean what it says, the Constitution in the Fourth Amendment gives an explicit role to the judiciary to approve surveillance and searches and seizures of Americans. And it's that role, as much as the congressional role, that the president has not only ignored, but claimed that he can completely override and run roughshod over in the name of some other constitutional provision. You look at being a strict constructionist of the Constitution, right here it says, this power belongs to the judiciary, and that it's when the judiciary's own power is at stake that it's likely to defend it.
And Lyle, you're I imagine, referring to the Hamdi case in which the administration took the position first that the court has no power to review this. Right. We are involved in a war on terrorism, and if we want to hold individuals who we suspect of being enemy combatants or individuals who are threatening the security of the United States indefinitely without charging them, giving them access to any due process, we can do that. And that's very much the same philosophy as the administration has expressed with respect to that. Well, they got shot down very quickly in the Supreme Court by even their own most conservative members. Right. So does that give groups that are opposing, such as opposing this program, does that give you some hope, some optimism that perhaps if it can ever get to the Supreme Court, as you say? I mean, that to me is part of the problem. I don't know why the cases without a victim, they may never get that far.
Right. I don't see any argument about why they can't get a warrant, and I think they'll eventually lose on that.
Okay. We need to stop now, and thank you very much for joining us. And in the next program, we will be talking about sort of large-scale approach that the president and this administration has taken, the imperial presidency and the incredible power that the president asserts he has with respect to foreign affairs and in some cases domestic relations, and we hope that when we are back that you will be as well. So thank you very much for joining us, and we'll see you again.